Hello and welcome to Unacademy. In a rare move, the President of India has invoked Article 143 of the Constitution, has asked 14 pointed questions to the Supreme Court, asking the views of the Supreme Court on this matter. This is what we call presidential reference. What is Article 143? Why was it invoked? What are these 14 questions asked by the President to the Supreme Court? That's something that we will discuss in this video. But this Article 143, which is the power of the President of India to consult Supreme Court, such a power is not available even with the US President. Under Article 143, President can refer any matter to the Supreme Court asking the views of the Supreme Court on this matter. But this matter can be broadly categorized into two categories. Either it's a pre-constitutional matter or it is a post-constitutional matter. Pre-constitutional matter in the sense something which may have happened prior to the commencement of the Constitution. Post-constitutional matter, something which has occurred after the commencement of the Constitution. But if it is a pre-constitutional matter, it is binding on the Supreme Court to give an advice. But if it is a post-constitutional matter, it is the discretion of the Supreme Court. Supreme Court may give an advice on this matter, but it is only an advice, which means this advice of the Supreme Court is not binding on the President of India. However, it has a significance of its own. That is something that we will discuss today. Now, to hear this presidential reference, the Supreme Court will have to set up a constitution bench. A 5-judge bench of the Supreme Court will have to be set up to answer these 14 pointed questions raised by the President of India by invoking Article 143. But what is this matter? Something significant happened recently in the Tamil Nadu case, which has a far-reaching impact on our constitutional setup. The matter was related to two provisions of Indian Constitution, two articles, Article 200 and Article 201. What does that mean? When a bill has been passed by the legislature of a state, it is sent to the governor of that state. What are the options available with the governor? Governor may either give assent to this bill, or the governor may withhold his assent to this bill, or the governor may send the bill back for reconsideration. Or there is another option under Article 201, which is the governor may reserve such a bill for the consideration of the president. These are the options available with the governor. But in Punjab case, Supreme Court had said when a bill is referred to the governor for assent, governor may either give his assent or may withhold the assent. But withholding the assent does not mean this is the death of the bill. The bill is dead. It can never become a law. No. As soon as the governor declares that I'm not going to sign this bill, the governor will have to send the bill back to the state legislature for consideration. And if the state legislature passes this bill again, it is binding on the governor to give assent to this bill. So now we have three options available with the governor. Governor may either give assent or the governor may withhold assent, but as soon as that, send the bill back to the legislature for reconsideration. Or the governor may send the bill to the president for reconsideration, reserve a bill for the consideration of the president. But there is no time limit mentioned in either Article 200 or Article 201. If the governor has to give his assent, in how many days? Not mentioned. If the governor has to withhold or send the bill back for reconsideration, in how many days? Not mentioned. The governor will have the power to reserve a bill for the consideration of the president. In how many days? How many months? How many years? Not mentioned in the Constitution. Constitution is silent on this time period.
Lack of consistency, declining motivation, fear of answer writing. These are the challenges that civil services aspirants face daily. To handhold serious candidates, make them mains ready, and inculcate discipline in their preparation, we have launched a path breaking online classroom program called Unacademy Platinum. This is your one stop destination to crack IAS in first attempt, where India's top educators will be guiding and mentoring you personally. I'm here to invite you to experience Unacademy Platinum for free. Register for the free experience session now, and together, let's crack it.
This is what happened in Tamil Nadu. When 10 bills were passed by the legislature of Tamil Nadu, sent to the governor was not acting on these bills at all. Which means what the governor was doing was exercising veto, which is what we call pocket veto. Some of these bills were then reserved by the governor of Tamil Nadu for the consideration of the president. And president also was not acting on these bills. There were some bills which were sent back by the governor to the state legislature for reconsideration. But when the bills were passed by the legislature again, the governor is not now acting on these bills. Looking at this power of the governor or the president to stop the bills passed by democratically elected legislature of Tamil Nadu approached the Supreme Court, and then a landmark judgment was given by two judges of the Supreme Court. I will emphasize on two judges because this is something very, very important, which I will tell you slightly later. The two judges of the Supreme Court said there is a time limit. When the bill is passed by the state legislature and sent to the governor has 3 months to decide if you are going to withhold this bill. The governor has 3 months to decide if you are going to reserve this bill for the consideration of the president. The governor, when you withhold this bill, then you can't say that this bill is dead, it can never become a law. Because once you withhold this bill in 3 months, you have to send this bill back to the state legislature for reconsideration. And if the same bill is passed again by the state legislature, the governor has 1 month to give assent to this bill. This judgment was heavily criticized by various people, calling it judicial overreach or judicial adventurism, or some even referred to this judgment as judicial despotism, a cruel performance of the functions of the Supreme Court. Including the Vice President of India, he criticized this judgment. More specifically, because Supreme Court invoked Article 142 in this case. What is Article 142? Supreme Court can give any order so as to give complete justice. And what is complete justice in this case? Supreme Court said these 10 bills, which were reserved either for the governor's or the president's address, now these bills shall be deemed to have been assented by these constitutional functionaries. That means even if there is no formal assent given by the president or the governor, these bills will become the laws. For the first time in the history of independent India, 10 bills became laws in Tamil Nadu without formal assent by either the president or the governor. And that is why Vice President of India called Article 142 a nuclear missile. But at the same time, there was another controversial yet significant ruling in this judgment. And what was that? When the bill, which is passed by the legislature of a state, it is sent to the governor can reserve such a bill for the consideration of the president. The Supreme Court said, the two-judge bench of the Supreme Court said that now the president will have to consult, ideally, will have to consult the court and seek the opinion of the court whether such a bill should be signed or not, assented to or not, completely removing the constitutional discretion which was available to the president. Now, president cannot enjoy her constitutional discretion. She has to go by whatever the courts will have to say. This was considered to be the classic example of judicial activism or judicial overreach, depending upon which side of the debate you are in. Some would say this is judicial activism. Some would say this is judicial overreach. And what if the president or the governor, they are not abiding by this time limit which has been prescribed not by the constitution but by the court? Then you can issue the mandamus. That means you can invoke Article 32, approach the court will issue the writ of mandamus, and the court will say, we command that governor and the president, you give assent to this. This was considered by many as breaching separation of powers, which is basic structure of Indian constitution. This was considered unacceptable by some constitutional experts, considered dangerous by the members of the ruling political party as well. And finally, on the advice of the government, the President of India has invoked Article 143 and has asked 14 pointed questions to the Supreme Court. And now Supreme Court has the discretion, because I told you it's a post-constitutional matter. And on a post-constitutional matter, the Supreme Court may or may not give an advice. But a 5-judge bench of the Supreme Court has to be set up to answer these 14 questions raised by the Honorable President. Question number 1. What are the options available with the governor when a bill is presented to him under Article 200? Because according to Constitution, the governor may give assent or withhold assent and then send the bill back to the state legislature for reconsideration and reserve this bill for the consideration of the president. Now, can you please clarify what are these options available with the governor? Because you seem to have rewritten the constitution. Please give us your opinion on this, your advice on this. Question number 2. Is it binding on the governor to give assent to a bill on the advice of the chief minister and council of ministers? When a bill is presented before him under Article 200 of the Constitution? Because the Supreme Court has said that when a bill is passed by the state legislature and sent to the governor has 3 months to either send this bill to the state legislature for reconsideration, and then once it is passed again, within 1 month, the president will have to give assent. The Supreme Court also said that if an advice is given by the Council of Ministers to the governor that you have to sign this bill, you have to take this action in 1 month. And in 1 month, you have to say, I am not going to sign this bill, but on the advice of the chief minister and the Council of Ministers. Long story short, if the chief minister and Council of Ministers advise the governor that don't sign this bill, and if you are agreeing with the advice of the chief minister and Council of Ministers, within 1 month, you have to say, I'm not going to sign this bill on the advice of the chief minister. But if you are going against the advice of the chief minister and Council of Ministers giving the governor the advice that you sign this bill, but governor does not want to sign this bill, you have to take this decision in 3 months and return the bill to the legislature for reconsideration. But once the same bill is passed again, within 1 month, you have to sign this. And within 3 months, you have to reserve this bill if you want this bill to be reserved for the consideration of the president. Can you please clarify, is the governor bound by the advice of the Council of Ministers in giving assent to bills? If it is, then there was no need of the constitutional discretion which was mentioned under Article 200 or 201. Again, it seems that the court has rewritten the constitution. Question number 3. Whatever decision is taken by the governor with regards to Article 200 of the Constitution, is it justiciable in the court of law? That means, can the court sit on the judgment, on the decision, on the constitutional discretion of the governor in assenting or not assenting to bills passed by the state legislature? Please clarify this question as well. Question number 4. There is Article 361, which talks about immunity for the president as well as the governor. That means when the governor is acting and doing his constitutional duty, when the president is discharging his constitutional functions, the decision, the duties performed by the governor or the president are not answerable in any court of law. That means there is an absolute bar on judicial review with respect to the official duties performed by the president or the governor. So here the president or the governor is discharging their duties according to the constitution with regards to assent to the bills in presence of article 361, which says that there is no judicial review. Is article 361 of the constitution an absolute bar on the judicial review? Because if it is absolute bar, then how can you review the non-action of the president or the governor when it comes to the discharge of the functions of assenting to the bills? Long story short, if there can be no judicial review under article 361 on the discharge of official duties by the president or the governor, they are also discharging their duties when it comes to assent to bills. Assent to bills is also the discharge of the official duty and functions of the president and the governor. How can then, in presence of Article 361, can there be judicial review on the decisions of the president or the governor? Please clarify. Question number 5, most important. There is no time limit prescribed in the constitution within which the president or the governor will have to give assent to these bills. In absence to this constitutionally prescribed time limit, how can you rewrite the constitution? And how can you impose time limits? 1 month, 3 months. In absence of a constitutionally prescribed time limit and the manner in which these powers will be exercised by the governor, can timelines be imposed on the governor by the Supreme Court? With respect to Article 200, please clarify, please answer this question. Question number 6. When a bill has been reserved by the governor for the consideration of the president, do you know what Article 201 says? If a bill has been reserved by the governor for the consideration of the president, what can president do to this bill? The president may either give assent or withhold assent. The president may also, through the governor, send this bill to the legislature of that state. And then the legislature has 6 months to act on this bill. If the same bill is passed again by the state legislature, then it is sent back to the president. But what president can do on this bill, it is not mentioned in the constitution. Constitution is silent on this. In absence of this constitutional clarity, which means that constitution deliberately gave discretion to the president, can this action of the president be justiciable in a court of law, be challenged in the court of law? That is question number 6. Question number 7. I told you there is no time limit mentioned in Article 201 within which the president may say, I am going to give assent or I will withhold my assent to this bill. In absence of these constitutionally prescribed timeline, can through judicial orders to impose time limit on the president, you seem to be violating the constitution or rewriting the constitution. Question number 8. You are saying, dear Supreme Court, that if a bill has been reserved by the governor for the consideration of the president, but how will the president act on this bill, decide on this bill? For that, you have to consult the courts, whether I should give assent to this bill or I should not give assent to this bill. Is it that we have to then again go through Article 143 of the Constitution? Which means under Article 143, the president has to consult the Supreme Court. President can refer any matter to the Supreme Court, asking the views of the Supreme Court on this matter. So when a bill has been reserved by the governor for the consideration of the president, can the president then each time have to invoke Article 143 to seek the opinion of the court to decide whether such a bill should be assented to or not? That amounts to rewriting the Constitution. And read this question number 8. In light of the constitutional scheme governing the powers of the president, is the president required to seek advice of the Supreme Court by way of Article 143 and take the opinion of the Supreme Court when a governor reserves the bill for the consideration of the president? This does not seem to be the language used in the original Constitution. Question number 9. Can a bill be challenged before the Supreme Court? Bill. No. A law can be challenged before the Supreme Court. Because Supreme Court does not believe in hypothetical situations. The Supreme Court cannot be invoked to answer hypothetical questions because a bill may not become a law. These 10 were bills. That means before they became a law, the judiciary is standing on judicial review. That is what the Supreme Court is asking. Can you adjudicate on bills before they become laws and then decide that these 10 bills have become laws? Please answer this question. Question number 10. Can the exercise of constitutional powers and orders of the president substitute in any manner under Article 142? Because under Article 142, Supreme Court can give any order so as to give complete justice. And you are giving an order under Article 142 to impose timeline. You are giving an order under Article 142 to decide what? That all these 10 bills are deemed to have been passed. And that is question number 11. Can, without the signature, assent of the president or the governor, can you say that a law passed by the state legislature can become a law without the assent of the governor under Article 200? Most importantly, Supreme Court said we are not rewriting the constitution. But since there is absence of time limit, we are just imposing time limit. That's it. We are not rewriting the constitution. But since there were no time limits prescribed, and now you are prescribing time limit, which means you are interpreting the constitution. If you have to interpret the constitution, for that, the Supreme Court has to decide by way of a constitution bench. That means a 5-judge bench of the Supreme Court has to be set up to review or to interpret the constitution. But the Tamil Nadu case was heard by 2 judges, not the 5 judges. So ideally, such a case should have been heard by 5 judges of the Supreme Court. And at the same time, Article 142 cannot be used like a nuclear missile without any limitations. Because Article 142 cannot bypass the Constitution, cannot violate fundamental rights. And by invoking Article 142, by giving complete justice, you seem to have violated the Constitution. Please answer this question. And question number 14. Whenever there is a dispute between center and the state, you have to approach the Supreme Court under Article 131. Since this was a dispute between the Tamil Nadu government and the governor or the president, who is part of the central government, such a case, Supreme Court only under Article 131 of the Constitution? Or is there any other way, for example, Article 32, to approach the Supreme Court? Or can it be only under Article 131? These are the 14 questions that have been raised by the Honorable President, and now Supreme Court will have to set up a 5-judge constitution bench to answer these 14 questions. We will have to wait and watch how the court, and more importantly, when will the Supreme Court set up this 5-judge bench, hear these arguments, answer these questions, which is going to have far-reaching impact on our constitutional democracy. Thank you for watching. Stay safe.